All set.
All right. Well, welcome everybody. Thank you for inviting me into your bedroom, your kitchen, your living room, your office, wherever you are. Thank you. I think that this is going to be a real interesting and informative, candid discussion about Michigan's no-fault law. So before I begin talking about the changes from an attorney's perspective, I have to give you my attorney disclaimer. That is that this is not legal advice. The information that I'm given is just for informational purposes. And if you have specific questions regarding any particulars of the change in the no-fault law, you're going to reach out to your insurance agent. And if you want the legal perspective, make sure you connect with an attorney that has some really good experience in dealing with Michigan's no-fault law. To put this change in perspective, I think we have to have a little historical point of view of where we were and where we have come from. So back in 1973, Michigan enacted the Michigan no-fault law. And so essentially what that did is that before 73, there was so much litigation, there were so many unpaid medical bills that the legislatures got together and said, how can we curb the litigation? How can we make sure that people are taking care of the hospital and their hospital medical bills are taken care of? So in 73, the law was enacted, and essentially it was a one-shoe-fits-all. What I mean by that is that if you were involved in a motor vehicle accident, regardless of who was at fault, your automobile insurance company would step up to the plate and pay your no-fault benefits, which include personal injury protection benefits. In the insurance agency world and in the legal field, that's referred to as PIP, P-I-P, personal injury protection benefits. Those included allowable expenses. Essentially, under allowable expenses, you would see the medical expenses being paid, attendant care being paid, anything related to medical under the allowable expense provision. There were also wage loss benefits that would be paid up to 3 years, replacement services, and some other miscellaneous benefits. So again, as a one-shoe-fits-all, the goal was to stop the litigation and make sure that the healthcare providers were paid for. Because what was happening is injured people were getting caught in the middle of suing the at-fault driver, trying to find coverage to pay these medical bills, and then their doctors and hospitals were turning around and suing the injured person to collect on these bills. So the injured person was getting caught between a rock and a hard place. To streamline this, the No-Fault Act was invented. Your medical expenses were paid right off the bat by your insurance company. The at-fault driver's insurance benefits, the at-fault driver's insurance would take care of their medical expenses. Then you may have a claim against the at-fault driver for your pain and suffering. So that's where the litigation part came into play. But when the law took hold, the opposite occurred. There was more litigation. There was more fighting between the insurance companies, who had priority to pay what. And again, the injured individual is getting caught between a rock and a hard place. Fast forwarding today, essentially all that litigation resolved all those issues. But in Michigan, I mean, I'm Dutch, all right? So every time I get my premium in the mail, I just go through the roof. And so what was happening is that a lot of people were driving around without automobile insurance. And so when there was an accident, the insurance companies were taking it on the chin for paying medical expenses. So what happened is the insurance companies, the trial attorneys, the hospitals, they got together and they were pushing for no-fault reform. And before the law was published, it sounded like a great thing because there was bipartisan support. And I was hoping that the change in the law, the reform, would add simplicity to processing claims and reduce the complexity of priority and who has to pay first. Well, then when the law was published and I was reading through it, I'm like, holy cow, they took a law that pretty much had gone through the wash and all the kinks were pretty much worked out, although it was expensive, but now they've essentially turned the thing upside down. By turning the law upside down, what they have now done, what a legislature has done, is they've given us options. So for those people that want to save a few nickels and dimes on their insurance premiums, essentially they can reduce their coverage for PIP, again, personal injury protection. And it's an opt-out scenario. That is that if you don't select one of these options, the default is that you're going to have unlimited full coverage, just like it was back in 1973. But what was happening again is the premiums were so expensive, people were driving around without automobile insurance company. So in my opinion, the insurance companies and the hospitals, they sugarcoated this thing to get it passed through the legislature by offering reduced premiums. Well, if you do a cost-benefit analysis, in my opinion, the savings that you get on your premium is not worth the benefit that you're getting if you have ultimate no-fault coverage. So with the law being so new, from my point of view, from a legal point of view, I think that all of us got to do a couple things. The first thing is I think that we all need to sit back for a year or so to let this law work its way through again, the wash and the dryer. Because there's a lot of ambiguities built into this law that attorneys are just scratching their head as, how is this thing going to play out down the road? The second thing that you should do is you should have a very candid conversation with your insurance agent, okay? You should meet with them in person and talk about the various options that are available and what that's going to do as far as reducing the premium and what are the savings and what are the benefits without reducing the premium. The third thing that you should do is you should consider buying an umbrella policy, all right? Because this change in the law has exposed all of us to some vulnerability as far as being sued for somebody else's medical expenses. And the fourth thing you should do is you should consider a protection trust. That's what we do at Carrier Law. So what we're doing is we're protecting all of our assets to make it money judgment proof. That way, if something does happen, most of our assets are in a protection trust. I know most of you have a protection trust. And if you don't, it should be something you should consider. So just to recap, wait for a year before you change any coverage. Have a very candid conversation with your agent about what is best for you, okay? Number 3 is that you should consider an umbrella policy. Again, have a talk with your agent. And number 4, consider some alternatives that protecting your assets. So with that said, I'm going to turn it over to Mike and David, and they're going to kind of get in the meat potatoes of what they see on their end as far as the coverages and the various options. And then we'll probably circle back and talk about, the Medicare opt-out. I'll give you my take on what that means for most people, and I'm sure Michael and David will comment on that as well. So I'll throw it over to you guys.
Thanks, Greg. I'll give you a quick introduction and tell you kind of who we are. So we are from the Browers Insurance Agency. We are an independent agent on Bretton Road here in town. So that means the independent part means we write for a lot of different companies. Personally, I sit on the board of directors for the Michigan Association of Insurance Agents, which is our trade association. And we were really at the table for most of the discussion with this no-fault reform. So I feel sort of uniquely qualified to talk about some of this. As Greg kind of hinted at, what came through quite literally in the middle of the night was not entirely what we expected, even though we were in the hearings and testifying and all that sort of stuff. So some of it was a surprise, and I think David and I would concur with most of what was said. The risk reward probably isn't there for reducing coverage, and we very much take the same thought. This is starting from scratch, basically, on having to relitigate all of these fine points of the law, and it's just going to take probably more than a year, in my opinion, to figure out what the real meaning is behind some of this stuff. So what David and I will do here is we've got just kind of an 11-slide slideshow, which will touch on some kind of high-level points that we're going through with our clients, because, the legislation is very long, so we're not going to go through the whole thing, but we'll touch on some high points. David, can you share your screen over there so that we can get the slideshow up? And once we got that going, I'll give kind of the introduction on the slides, and then David will jump in and start talking some coverages here. We have had, as I talked to him, my watch is talking to me here. As Greg said, and Greg and I talked about previously, we have had a number of Medicare enrollees call to discuss some of the the opt-out, because as a Medicare enrollee, you can completely remove medical coverage. And so certainly if any of you are enrolled in that portion, we want to make sure that you pay close attention towards the middle of our presentation when we touch on some of that. David, are you having trouble with that? I can probably do it over here.
Yeah, if you can do it, that'd be great.
Cool. Let me share. and hit present. All right, can you folks see that?
What's all the fuss about?
Yep, you can see my slide okay?
Yes.
All right. So what we're going to talk about today is what your choices are, because you have a number of choices from keeping unlimited to picking a dollar amount to, like I said, completely opting out. We're going to talk about the difference between auto insurance and health insurance, right? We're talking about medical coverage here, but not everything is equal. The coverage on your auto policy, that personal injury protection that Greg alluded to, is much more comprehensive than any individual plan, including Medicare. And then finally, I'm going to bring it back and talk about some of that umbrella coverage that Greg talked about too, because what really happened in this law is we were all exposed a lot more to further lawsuits. So I'm going to turn it over to my teammate here, David, and he's going to talk about some of your medical coverage choices.
Thank you, Mike. Yeah, to touch on what Mike and Greg both alluded to, this is a pretty expansive law, and to go through everything would frankly bore you and not be beneficial, because you wouldn't be able to remember all the details. So we're really trying to focus on some of the big three main points that you can take away from and remember. You've probably heard a lot of different information from the newspaper or Wood TV8 or your neighbor, whoever it may be, on what their take is and how everybody's interpreting it. There's a couple things that have been put out there that are correct. Some people have I guess a misconstrued version of what's going on. So we really want to set the record straight and make sure that you guys are clear on the most important parts. And so the first part that I'm going to touch on here is the medical coverage choices. And so like Greg alluded to, the law changed to the no-fault system back in 1973. So since 1972, all Michigan drivers have been mandated to have the unlimited medical coverage on their auto policy. You couldn't reduce it, you couldn't decline it. Everyone was mandated to have that unlimited coverage. And then again, like Greg alluded to, if you look on your auto policy itself, where it says all the different coverages and lists your deductible and things like that, one of the line items on there says personal injury protection, and that is the medical portion of your policy. And so from 1972 till now, you've been mandated to have that unlimited coverage. Options now, after the reform took place, which was effective on July 2 of this past summer, the options now include staying with that unlimited coverage, but you can also go down to $500,000, $250,000, $50,000, or opting out entirely and having $0 in medical PIP coverage on your policy. There are a couple caveats that we want to make sure you're aware of. The $50,000 option is only for those who are enrolled in Medicaid. Very important that we state that. And then the opt-out option entirely is only for those who have what's deemed to be a qualified health coverage policy, which you have to get a specific letter from your health provider if you still have private insurance. You have to get a specific letter from your health provider stating that they are a QHC. Or if you are enrolled in Medicare Part A and B, you have the option to opt out entirely and go with zero medical coverage on your auto policy and rely solely on Medicare. And so yes, to go to that zero option, you got to have the letter from your insurer. And if you want to go with the Medicare option, if you're enrolled in A and B, you just have to submit that card to your agent.
And an important distinction, just as a note, if you were to pick like look, I have a laser pointer, the 500,000 or 250,000, that is per person in the accident. So if it were you and a spouse in the vehicle and you were injured and you picked a lower limit, it would be, say, a 500,000 per person per accident limit. It's not like a lifetime limit or a household limit, but I just want to point out that distinction.
All right, so to expand on that a little bit more, the one thing to note that's very important, because it's easy to forget, is that the medical coverage choice, whatever you pick, it must be resubmitted with your carrier each renewal. Your carrier will send out a form to you with the selections available, and that will come usually a few weeks before you reach your renewal. And important to note that we noted here, if you do not select an option your policy will renew with the unlimited coverage. And so it's just important to note that hey, if you want to opt out, obviously you have that option, or you want to go down to a lower limit, but you got to keep selecting that limit if you want to stay with that year after year, or your policy will default to the unlimited option. So just important to note that. Similar to what the prior law was, in that you had unlimited coverage on your auto policy, but you could have your health insurance, if it was private health insurance, and the policy was set up that way, and not all policies were, and not all policies are now. You can have your private health insurance set to be the primary payer in the event that you were injured in a car accident. And so the event that, hey, you had private health insurance and you were injured, let's say you had priority health care, priority is the primary payer, and then the auto insurance would fill in the gaps, deductibles, co-pays, co-insurance, things like that. And so that's the way the law was. That's still an option moving forward. So if you still do have private insurance that will be the primary payer, you can have your auto policy set up that way. And you do see savings as a result of that, because obviously your health insurance is taking the majority of those expenses, and the auto insurance is being secondary. And so that is not an option, however, with Medicare. It's important to note that. With Medicare, Medicare will always be a secondary payer. And so if you have unlimited coverage, 500,000 or 250, Medicare will be secondary. They will not be primary. That's the way they operate. The only scenario in which they are going to be the primary payer is if you opt out entirely. And then at that point, you're just relying solely on Medicare to pay for any injuries that you have in a car accident. And so if you do opt out, we're skipping down here to the last one. What's really, really important and a very big part of how PIP is going to work moving forward is that if you opt out of the medical coverage, so you're going with $0 on your policy, you're relying solely on your private health insurance or Medicare, Medicaid, and you lose that qualified health coverage status, you have to notify your carrier within 30 days. If this is not updated and your carrier is not made aware and they can adjust your policy accordingly, and you get into an accident, 31 days after your status changes, there's no coverage at all. There's no state fund that kicks in. You are without any coverage from the policy. So very, very important. With Medicare, that's not so much of an issue, but if we're talking about private health insurance, you lose your job and then you lose your benefits. And in the interim, if you don't have coverage and you had elected to opt out, got to make sure that you notify your agent within those 30 days so they can adjust your policy accordingly. Because, yeah, we don't want the scenario to pop out where, hey, yeah, you get into an accident, you forgot to notify your agent, and now you're kind of high and dry. Greg, you like a question?
Yeah, David, just on that note, so I don't lose track, and that's a very important key, because if you don't carry no-fault coverage in the state of Michigan, you do not have a viable claim against the at-fault driver. Okay, you lose all your rights. So people are driving around with no insurance and at no fault of their own. They're involved in a catastrophic accident. You have no claim whatsoever against the at-fault driver. And I think that's going to be the same here. If you lose your coverage because you failed to put the carrier on notice of your loss of your qualified health insurance, and then somebody hits you, you have no viable claim against the at-fault driver. Okay, so it's a very important note. If you do opt to one of these opt-in positions, that you mind the store. If you lose your coverage, you got to notify the insurance company right away. Thanks, David. Sorry about that.
No, that's fine. That's a good.
That's good.
Mike, if you want to go to the next slide. So it's also important to note, and one of the smaller parts that has changed that hasn't gotten a lot of publicity, but it's not surprising, is who the PIP applies to, the medical coverage, who that covers on your policy. And so the medical coverage on an auto policy applies to the named insureds of the policy, as well as all current resident relatives. And so that's really important to note. And so to go through a couple of examples here, let's just say, your out-of-state 19-year-old niece, comes to live in your house as she attends the local college for 9 months a year. That's going to make her a resident relative of your house. She's considered a resident relative, and so the medical coverage on your auto policy automatically covers her. Even if she has her own insurance for, for Massachusetts or whatever it may be, if she's in, your car and she gets injured in a car accident, she's covered. Your policy extends to it. And so it is important to note that you're going to want to make sure that she is listed as a household member. Again, this is just an example. So if you have another person who is, is a resident relative of yours, but is not listed on your auto policy, you got to make sure that they are. Even if they're a minor child, you got to make sure that your agent is aware that you have another resident relative in your household, because the PIP coverage will apply to them, and the premiums need to be adjusted accordingly. So that's really important to know. And then kind of the other example is, hey, your old college friend's son, who's not related to you in any way, is the same scenario, comes to live in your basement for 9 months a year, attending college. He's not a relative. So the medical coverage in the PIP on your auto policy does not apply to him. However, there's a small caveat to this, in that if it's a scenario where, hey, he really needs to get, he's buying a car in Michigan and he needs to get some insurance, you can add him to your policy and get some medical coverage for him. He just needs to be added as what's called a named insured on your auto policy. Important to know, because if he's not added as named insured, it doesn't apply. So those are a couple of scenarios that we have seen firsthand just in the last 4 or 5 months or so, and just really important to remember that medical coverage applies to all resident relatives that are in your household together. So
I think it's worth pointing out 2 things. One is, it didn't used to be like this, right? The previous version of the law, if you had your college buddy's kid in your car and he got hurt and he had no other medical coverage, your auto insurance would pick him up. Because of the way the order of priority used to work. So it's just a big distinction. And then the other side of it is, if you've got, or your kids have perhaps, college-age children who graduate and go out on their own, and they're still listed on mom and dad's policy, driving mom and dad's car, there could be a situation where those kids are no longer covered, even though you're paying the premium because they're a driver and they're listed on the policy, but your insurance carrier doesn't know that the person moved out. There could be no coverage for that. And so you get a situation where a child becomes a non-resident because they graduated and they got their apartment and they got their big boy or big girl job, but we didn't get them their own car insurance policy. They could be in a situation where, like they're a listed driver on your policy, but they're not a resident, so we're not going to cover their injuries. So this resident relative thing became kind of a huge thing in the change.
So the question that obviously everyone wants to know, and as an agency we've gotten a few hundred times, is how much money are we talking about? How much money can I save with these different options? And so we'll start with, hey, prior to the reform, prior to July 2, there was a fee on your auto policy per car, which was called the MCCA fee, which stood for Michigan Catastrophic Claims Association. And that fee paid into the Unlimited Medical Coverage Fund. And so this fee, after the reform has taken place, this fee is automatically being reduced to $100 per car per year, even if you stay with the unlimited coverage. And so on that portion of the policy per car, you're going to see savings of approximately $120. And to go further, that's with the unlimited coverage. If you'd stay that, you're still looking at some savings. If the medical coverage is reduced to $500,000 or lower, that $100 fee per car is eliminated entirely. And so those are some immediate savings that a lot of people have elected to do, and that is a portion of the policy that, they've immediately adjusted for the MCCA fee. In terms of other premium options, we have found that there is very little premium difference between the $500,000 and the $250,000 options, just because most medical claims are going to fall well below both of those. And so for the most part, yeah, what we found is, hey, for your average, 2-car policy that might be $1,700 a year, there might be $20 to $30 in premium difference between those two options. Don't quote me on that. That's just an estimate. Those are the numbers that we've been seeing, but overall, there's just a very little premium difference between the two. And so it's just important to note that. And then at the bottom, obviously, the greatest savings are going to be by opting out entirely. And so those are where you are going to see the biggest premium drop off is obviously the fee per car per year is going to be eliminated entirely, as well as the premium that pays for the other PIP coverage leading up to that amount as well. And so the next point that we're going to cover, so that's the first point is, hey, what are the medical coverage choices available to you? Second point that we want to make sure everyone is clear on is the difference between auto insurance and medical coverage versus health insurance, private health insurance or Medicare, Medicaid. In that auto insurance medical coverage is much more comprehensive than health insurance, Medicare, Medicaid in what it covers. And some examples of what auto insurance medical coverage includes that regular health insurance or government health insurance does not are long-term care, in-home nursing care, alterations to your home or your vehicle, or medical transportation to and from appointments. And there's a whole list. And those are 4 of 30 that we could probably go through, but those are really the big ones that we want to make sure people are aware of. In that, yeah, in the worst case scenario, which is what insurance is for, in the absolute worst case scenario, you're catastrophically injured, you got to go to a long-term care facility for a period of time. That's going to get obviously very expensive very quickly, and so it's really important to plan for that worst case scenario. And so, yeah, very important to note, auto insurance medical coverage will pick that up and those expense. And having that unlimited amount is what we had before, but obviously there are other options available. And so it's important to note that no matter how good your private health insurance is, whether you get it through an employer or buy it on the marketplace, or no matter how good your Medicare Advantage or Medigap or Medicaid may be, those are things that it will not pick up. And so very, very important to note that, because those can obviously be very big expenses in the event that, hey, you got to be in a long-term care facility for 6 months. That could be an enormous expense. And so just very important to plan accordingly. And yeah, if you would be, if there is paralysis or permanently disabled as a result of an injury, very, very important to plan for that. Also important to note, depending on how your Medicare is set up, if you have an Advantage plan versus Medigap, but also private health insurance also has deductibles, co-pays, co-insurance, maximum out-of-pocket, network restrictions, things like that. In the event that, hey, there's a really serious incident and you got to have, multiple surgeries, you hit a maximum out-of-pocket. I know with Medicare Advantage policies that we're looking at right now, oftentimes that's $5,500, $6,000 for a year. Obviously, that's a big expense to pay for it. If there is an incident that maybe carries over from year to year, in which you got to consistently have some work done to help an injury that you had, that number can obviously rise year after year if you're continually spending money on that. So really important to note that difference, and that auto insurance medical coverage is much more comprehensive, and no matter how good you think the policy that you have with Medicare or Medicaid is, there are some things that it doesn't pick up, and those things can be very expensive.
We're going to get into the liability changes in just a second here, but I just want to give you an example of some of the questions I've received about Medicare specifically. A lot of people will look at this list, long-term care, in-home nursing, medical transportation, and say, well, okay, I've got Medicare and I will opt down to $500,000 because Medicare will pay all my hospital bills and stuff, and I'll just use that $500,000 for these things. And going back to what David said earlier, you have to remember that Medicare is second. So if you elect a $500,000 or a $250,000 limit, Medicare won't pay until it's been those 500,000 or 250,000 has been exhausted. So keep that in mind. Number two, just to reiterate on David's point, if you get injured in December, you're going to pay your copays and deductible, and you're still in the hospital in January, you're going to pay that again. And if you've got a $6,000 out of pocket, you know, you just spent $12,000 on an injury that saved you a couple of $100 on your auto insurance. So that goes back to Greg's point. The risk reward isn't there for most people. You can see some significant savings by opting out because you have Medicare, but again, one auto accident, you've burned through that savings. So it's not been wise for most of our clients. See if I can make this thing go to the next slide here. Pointer. All right, liability changes. So we'll go through this rather briefly, but as Greg said, we are now in a situation where you can be sued for medical expense, and you did not have that before July. You just couldn't be sued for the other party's medical. If you look down at your phone and you hit somebody and they were critically injured, it wasn't on you for their medical, just for punitive pain and suffering, serious disfigurement, things like that. So you just couldn't be sued. After reform, you can be sued for the other party's medical. So there is certainly a certain segment of the marketplace that finds no value in their insurance coverage. It is a requirement, and so they opt out of everything they can opt out of. And so they have no medical coverage, or they buy $250,000 in medical coverage. And you rear-end them, and they have $1 million injury. And if that were the case, you can be sued for the difference. And so in that case, you're looking at a $750,000 judgment. That was just not a thing before no-fault reform. You could have always been sued for punitive damages. You injure a construction worker and they can't work, a neurosurgeon. I had a situation where a physician was hit while standing behind his car, and he injured his knees and he couldn't work anymore, and the other party was sued for that, for his lost wages. So that's always been a thing, and so you carry this bodily injury liability coverage. But now we need to add in the medical portion of it. So this right here shows kind of the example that I was talking about. You got an individual who elects $250,000 and you injure them, and you're on the hook for the balance between the coverage they elected and what their other medical insurance will actually pay. And so that's going to be a big exposure. The second point here is that your medical coverage on your policy, you say, well, I bought unlimited, I should be fine even though I hurt that person. But your medical coverage doesn't pay for the other party's injuries. You have to carry the bodily injury limit, and to Greg's point, an umbrella on top of that. So let's talk a little bit about that. Generally on your auto policy, it's going to be the first numbers you see. They're really big numbers, 100,000 per person or 500,000 per person. Before the reform, the minimum coverage you could buy on an auto policy was $20,000 per person. So what that means is, and $40,000 per accident. And so if you injured somebody, there is a $40,000 bucket of money, but any one person in the accident can only get $20,000. And so the state said, or the legislature said, well, these are definitely going to be bigger lawsuits, so we're going to scrap that $20,000 per person, $40,000 per occurrence, and we're going to increase that. So now the state minimum is $50,000 per person, $100,000 per accident. But they did something else, which is even more interesting. They created what's called a default liability limit. And so if you have less than $250,000 per person, $500,000 per occurrence medical or bodily injury liability coverage on your auto policy, that it will automatically be increased to that limit. So if you're driving around, a lot of people have 100, 300. You might be familiar with that term. 100, 300 limits. It was a standard for I don't know why, and I don't know how long, but that was just a lot of agents were selling that. If you carry that limit and you do not return a signed form saying you want to retain that limit, your policy will renew at $250,000, $500,000. That is what the state says. Now, at the Browers Agency, and probably Greg would agree, that's too low as well. $250,000, $500,000, that's not high enough. And we recommend at least $500,000 in liability on your auto policy. And then, like Greg said, we recommend at least $1 million umbrella above that. You need to talk to your agent about the pricing in that. You need to talk to your agent about what you're trying to protect, and talk to your attorney and those sorts of things, maybe a financial planner, those sorts of things. If you are found at fault and the judgment against you is greater than your limit, they're going to come after your assets, which hopefully you've protected in a trust. and they're going to come after, if applicable, any future income. Michigan has a 25% income garnishment law, which is huge. So when we're thinking of what kind of limit do we need to pick, we might look at what sort of assets are outside of our trust and might be exposed to a judgment. And we might also look at any future income and can that be attached in a lawsuit. Those are the things we're trying to protect. That kind of wraps up our part of the presentation today. We'd love to get some feedback from Greg if you've thought of anything along the way here. But the bottom line, if we can summarize this in 2 minutes, is you can save a little bit of money by reducing your medical coverage, and people will do that. You know, Greg's joke about Dutch, I mean, I'm the blonde hair, blue-eyed guy, I'm as Dutch as they come as well. But we have to look at the risk reward. Is it really worth saving even a couple of $100s to risk many thousands? Maybe not. And at the same time, we have been greatly more exposed in the liability arena. So it's very important that we keep high limits. And it's also important to note that some of the savings that you're going to see in these auto policies will absolutely be eroded in the increasing cost of liability coverage. The only other state who's had a change even similar to this was New Jersey. And one of the largest auto insurers in the country told me they saw liability premiums triple in 5 years because of the liability exposures. We can't just do that in Michigan. This is in the weeds stuff, but they changed some of the way we file rates now, and you have to be able to prove the losses before you can take a rate increase. And so we're going to see that come through the years. You're going to see some increase in those costs as well because of the greater exposure. So to wrap it up, we probably keep unlimited for at least a few years. Let's see where the chips fall, like Greg said. Bump up that liability coverage. Talk to your agent and talk to your attorney about that. Greg, any thoughts?
Yeah, thanks. Just two thoughts. One, but with the Medicare opt-out provision, I get it. It's very appealing to a lot of folks out there. I get it that your premium is huge, all right? But with Medicare will not cover long-term care. And like Mike and David have pointed out, if you're involved in an accident and you need long-term care because of your injuries, you're on the hook on that. Medicare is not going to step in and help you out, all right? And right now, and Chris can comment on this, but with skilled nursing care, I mean, it's running close to $10,000 per month. So by dropping the all-inclusive, no-fault benefits, you're giving up that. The other point is that if the other fault is at fault, if the other driver's at fault, causes you injuries, and you're on Medicare, and Medicare picks up the tab on your medical bills, if you sue the at-fault driver for your pain and suffering and all those incidentals, Medicare has 100% lien on anything you collect against the at-fault driver. So you're the person that's in the hospital bed. You're the person that's in extreme pain. You're the person that has these lifetime limitations. And you make a claim against the at-fault driver, and they pay you some money for your out-of-pocket, pain and suffering. Medicare is going to swoop in and take dollar for dollar what they paid out on your Medicare health benefit. And the same thing with your healthcare insurance. A lot of these premiums have what is referred to as subrogation rights. What that means is they step into your shoes to recoup any losses they pay out as a result of an at-fault party's negligence. So again, you may have a catastrophic claim, your healthcare provider steps in, helps you out with the medical bills, great. You sue the at-fault driver for your pain and suffering, that healthcare provider is going to swoop in and take every dollar that they paid to reimburse themselves their out-of-pocket loss. So you have to keep that in mind. With Michigan's unlimited healthcare provisions, there's no swooping in. All right, if you sue for bodily injury and you recoup, there's no reimbursing the auto insurance carrier. So that's just something you got to take. You have to look at the big picture. So you may be saving a few pennies, but at the end of the day, are you going to lose a few dollars?
Yep.
And you can't be penny wise and pound foolish on this stuff.
And we see that driving some of the liability premiums too. Our personal injury attorney, who we have as clients, right? We insure people who do all kinds of things. We've had some conversations, and they indicate that that's likely to drive lawsuits, not necessarily a frequency thing, which is what we're really looking at here. There's going to be a lot more lawsuits, but the severity of lawsuits, the size of them will be bigger because the attorney says, well, we got $1 million worth of pain and suffering here that we can go after. But man, I know Medicare is going to come after that $250,000 that they paid out too. So we're going to have to sue that other party for $1,250,000. And so as you're electing your own liability coverages, that's just something you have to consider, is that what used to be, a $500,000 lawsuit can easily be $1 million now if we had AeroMed and intensive care for 2 months and all this stuff factored in, and they're going to come after that after you get paid.
Yeah. And another thing, so, and I don't know if you guys agree with me on this, but with coordinated coverage, so back in the day, I used to be a plaintiff's attorney, all right? I used to sue at-fault drivers, and I would come after you for everything you got. But I used to represent individuals against the auto insurance companies as well. And when you have coordinated coverage, you have two insurance companies pointing the finger at each other, who's going to pay first. It's a priority issue. And in the middle, who's caught? It's the injured person. And all of a sudden, they got the doctors and the hospitals and the pharmacy and the ambulance people. They're all making a claim against you because you got two insurance companies fighting against each other who has priority. I'm the injured person. I could care less who has to pay it. I just want it to get paid.
Just pay.
And I don't want to have debt collectors knocking on my door, and then that's going to create problems for me. So always tread cautiously. And I don't know where Mike and Dave come on this, but with coordinated policies, you save a few dollars, great. But in long run, are you going to be caught in the middle between insurance companies fighting who's priority?
Yeah.
So that's just, you got to take that into consideration when you're talking to your agent. How can I best protect myself? How can I get my bills paid without any flim-flam going on between the insurance companies?
Yep. And it's interesting that if you have a discussion with like a physician who really knows their stuff, they would never elect coordinated coverage because they want the auto insurance to be primary because it was always the best coverage and there's no finger pointing. But for most people who are never in an auto accident injury, they can save $200 by going to coordinated and they do it. So that's an interesting point. Certainly, if money aside, primary is certainly the easiest way to settle a claim.
Right.
I got a question here from Chris. Somebody says their adult son uses their home address as his address for his driver's license and voting purposes, but he lives somewhere else. He separately insures his own vehicle. It's not listed on our policy. Is the use of our address a problem for us? I think that you need to talk to your attorney about that. When it comes to the PIP coverage and who is responsible for carrying the PIP coverage, if he has his own auto policy and he's a named insured, that would be the primary policy. And the other thing to consider is that when deciding whose policy is going to pay, right, we talked about the college kid who moves out, they're looking at something called domicile. By law, and again, I'll use Greg's disclaimer, I am not an attorney, this is not legal advice, but by law, you can only have one domicile, right? And so you're either at this apartment or at mom and dad's house, and so they look at all kinds of stuff like, do you have clothes at that house with intent to return? Like when I went to college, I moved out and never slept at home again. Nothing against my parents, that's just what I did. Some people come home for Christmas and summer, and so that gets a little gray. So I would think that provided your son has his own auto policy with personal injury protection, there's not really any issue whether he would have coverage. Could there be any liability issues and things like that because your address is on his? I mean, I would not allow that. Let's just, so I use very simple things when I'm talking to some of my insureds about, I'm on the title to my kid's car, and I'm very simple thing called risk avoidance. Don't create gray areas. So I would absolutely say it's time to change that, get a PO box, get a UPS store address. Let's not involve ourselves in other people's lawsuits, potentially, even if it's your own kid.
Yeah. And on that note, so defense attorneys for the insurance industry, they're always looking for escape hatches or back doors. And so an insurance company could look at that and say, look, you haven't been honest with us about where you're living. Where you're living may increase the risk of the policy, right? And an insurance, and again, maybe I'm stretching this a little bit, but they're always looking for a way not to pay, right? And so if they say you haven't been honest with us regarding your mailing address, is that going to be justification to deny coverage? I don't know, So you always have to.
It's called material misrepresentation, and you don't want to mess around with it because they will rescind policies and things like that. So
that's right.
Even if he's got his garaging address on his policy correct, but his mailing address is yours, that's really okay. It just feels too gray for me perhaps there's some, and certainly there's a reason he does that. I don't need to know why that is, but I just wouldn't do it. There are plenty of other virtual addresses you can have. I wouldn't want it at my house.
Does anyone have any questions for Mike, David, or Greg?
It's too easy.
Well, again, just to recap, Chris, and you guys have done a really good job. Just sit back, let things, go through the wash, talk to your agent, have a real candid conversation about things, all right? And savings versus risk versus savings. Consider umbrella policy. Make sure your stuff is protected, all right? The protection trust. Something, a mechanism that a money judgment creditor cannot get access to. Because Mike is right. We're all on the hook now. Our risk of liability has just gone up because of this change in the law. And we're going to see that more and more as time goes on. And I think there's going to be more and more rebellion against this no-fault reform. You have to follow the money. Who was behind this reform? It was the trial attorneys, it was the insurance industry, and it was the hospitals, okay? When any of those three all get together and they agree on something, it's not good for the working middle class. It's not good for you and me. It's good for them. And you just have to kind of follow the money trail a little bit. Again, yeah, they sugarcoated it with some sprinkles and it looks good and it smells good. But when you get into it, when you take a bite of it, it's going to pack a punch.
I think that's a good point. Yeah.
I'm hungry. That's why I'm thinking lunch and food. So
yeah, a fine summary, Greg.
Yeah, of the hundreds of customers that Mike and I have talked to over the last 4 months, I'd say the vast majority, like 80 to 90% have said, all right, I just kind of want to keep it the way it is. People have been pushing for no-fault reform, for decades. But once it's finally here and once we're into the meat and bones of it, once kind of we get into, hey, this is the savings versus kind of the risk reward, the vast majority of our customers have said, oh, wait, actually, you know what? I want to keep it the way it is. And I think, yeah, although premiums are a little bit higher than what we'd like to see them, that risk reward wildly skews in the driver's favor in terms of the coverage you get for the price you pay. And so, yeah, people have been harping on the system, and obviously there were some changes they could have been made, and they could have done it better. But yeah, the vast majority of our clients, once we've done this exact pitch, I've given this exact pitch, probably 150 times. The vast majority of them have said, actually, you know what? Let's keep it the way it is. It's definitely worth it. I'll pay a little bit more to have just that peace of mind. I don't want to fuss with this.
Very good. Well, I thank you guys so much for sharing your expertise with everyone here. And I will be sending out the PowerPoint presentation and the recording to everyone as well. So again, I thank you so much.
Thank you, everybody.